with the Apartment Owners Association, and it is just a pleasure to have you with us today. And we have a new year, 2026, I believe will be amazing. And I'm glad you're here to join us for this live stream. And there we go. Make sure your phone's off, right? And we're going to be talking today about changes that we've made to the Berkeley rental agreement. We have changes for the Berkeley rental application. There's new municipal code language that needs to be in there, and we're in the final stages of getting that proofed. We've also come up with, we've made a little change for the Berkeley 3-day notice, so that just to include the date of the expiration of the notice. So there's lots of stuff in Berkeley that's changed. And then we also have, so this is obviously a live stream and a Zoom. So we're glad that you're in the Zoom meeting. Definitely join in the Zoom because we'll be answering questions there first. If you're watching on the live stream, that's great. Getting into the Zoom meetings just a little more engaging, and we do better with answering questions and just being able to go back and forth. And if some of you may be watching on AOAUSA.com, and you may probably are a new member, so we want to welcome you. We do have like a member orientation, and actually, we're going to do a member orientation live in San Jose and then also in Alameda, I believe next week. So next week we'll be in Alameda, and I believe Pritt's going to be speaking. Is that right, Sybil? Pritt will be speaking at that one.
I thought it was Rich, but maybe
Oh,
I'm
is
wrong.
Rich going to speak? Yeah, anyway, so we'll have someone from Rich Beckman's office, and they've just been so great. So thankful for them. And anyway, so those are just a few of the updates. And I don't know if Sybil's going to cover it today, but one thing that a lot of people are not aware of right now is the change with the way that the things are being postmarked. So if you have if you're serving a notice through with the mail, how it's postmarked changed as of December 24th. And so that really could be messing you up, and I hope it's not. Um, but yeah, you need a certificate of mailing, I think it's called. I have to go back and look at it. But basically, you need to prove the date that you mailed it, because the way that it's like they're removing a step from the process, so that the day that the processing facility gets it is when it gets postmarked, which is not the day that you put it in the mail necessarily. So anyway, I'll after we in the Q&A time, like I can find exactly what it is, but I think it's certificate of mailing, not to be confused with um, the other certificate. Anyway, it's Form 3817. I remember 3717, 3718. Can't remember what they call it. But anyway, all right. So I hope we see you next week in person, whether it's San Jose or Alameda. Or hopefully if you're in Berkeley, hopefully we get all your questions answered today and you don't even have to go. But all right, our speaker today is Sybil Quaye. She's uh, earning her law degree. Did you, maybe that was old. You may have it now. Where are you at with that, Sybil?
No, earned my law degree in Ghana, and I wrote the California State Bar exam. But before that, I have an LLM degree from University of Colorado at Boulder.
Okay. And yeah, you got your master's there. And really, you've had a great reputation, and she's even helped us proof the forms. And she's been working with Richard Beckman, how many years now?
Since 2022,
Okay, yeah, so it's been 3, 4 years. And
right?
anyway, she focuses on landlord-tenant issues and focuses everything. And so she's not just someone coming in that's practicing, marriage or marriage law or family law or something like that. She's focused on landlord-tenant stuff. And so it's really a pleasure to have you on. And I just want to give you the floor now and let you get started.
All right. Hello, everyone. Happy New Year. Um, This presentation, we're going to talk about the key changes that we made to the lease agreements for Berkeley. And I'm going to give you some of the reasons behind those changes that we made. We're also going to talk about the stove and refrigerator requirements required by AB 628. Next, we will talk about the rent reporting requirements that are commonly used. And lastly, I will talk about how to navigate Berkeley's Notice of Tenants' Rights, which is a form. All right, I'll dive right in. So, the first thing I noticed when I saw the Berkeley rental agreement that Jeff sent me was that I saw at the top in section B, he had crossed out the part where it says every time thereafter shall become a month-to-month tenancy unless 30-day move-out notice is given by either party. So I believe he crossed that out because if properties are covered by the Berkeley rent ordinance and the just cause provisions, then it means that if the tenancy expires, you cannot evict the tenant because an expired tenant's tenancy is not one of the listed just cause reasons. You can only terminate the tenancy based on, for example, non-payment of rent, if they breach the lease, if they do not allow entry, or it could be if you want to move into the property or you want to take the property off the market. So if it's not under any of those specific just cause requirements, you cannot terminate the lease. So due to that, he crossed out that part from the lease agreement. The next thing that I saw was that the lease now has something about security deposit, and that's because there's been numerous changes to the security deposit law. First thing is for rent, which is not a recent law, it's been there for a while. And I'm not sure if landlords know this, but you cannot require the tenants to pay rent just via cash or EFT. You have to provide another method which is not cash or EFT. For example, money order, check, those payments are accepted. The only exception to this rule is if the check was returned. So if you get a notice either from the tenant not to cash the check because it was dishonored, or if you get it back from the bank due to insufficient funds, you can send a notice to the tenant, letting the tenant know that the check was dishonored and that from in the next 3 months, they have to send cash payments. Before you do this, you have to send a notice to the tenant and it must contain a picture of the dishonored check. And then also it must be in accordance with Civil Code Section 827, which is the change of terms provision. And you also might have to comply with the service requirements. The next thing that I saw on the lease agreement was the late fees. So for Berkeley, there's no prescribed cap to late fees, unlike Oakland. Oakland caps it at 3%. However, Berkeley does not have a cap on late fees. However, the general rule is that late fees should not exceed 5% of the rent, of the monthly rent. And then also another thing that I flagged on the lease was that it has stated late fees are deemed additional rent. However, I explained to Jeff that late fees under no circumstances must be considered additional rent. And the reason is because I have seen situations where a landlord would include the late fees on a non-payment of rent notice, and that would render the non-payment of rent notice defective. And then you have to start over the process.
So I think it was good to just take that out, because I think in the past that's something that that worked when people inadvertently put in the late fee on it, but that was maybe 10 years ago when that worked. And so that was something that, yeah, that was a good thing to take out. And other attorneys that we counsel with, they're like, yeah, it's a good time to take that out.
Right. So some of these laws, they went into effect prior to 2025. Um, so for example, the security deposit cap, it went into effect July 1st, 2024. At first, it used to be you can charge 2 months rent for unfurnished units and up to 3 months rent for furnished units. However, in the recent law, you can only charge up to 1 month's rent. And the purpose of this is to allow increased access to housing facilities for tenants due to financial constraints. And yeah, basically improve access to housing due to increased housing cost. However, there is a small landlord exception, and this means that if the owner is a natural person and owns less than either two rental units or less, two rental properties and fewer than either 4 units or fewer than 4 units, then that landlord may charge up to 2 months rent as a security deposit. The owner can also be an LLC, but all members of the LLC have to be natural persons. Other provisions of the security deposit law still have to be followed. For example, there's this new law which went into effect April 1st, 2025. And it basically states that the landlord, any tenancy after April 1st, 2025, the landlord must photograph the unit after the tenant vacates, but before cleaning or repairs. After the landlord cleans and repairs the unit, he has to take another picture. And if deductions are made, he or she has to include both sets of pictures with the itemized security deposit disposition. Effective July 1st, 2025, the landlord has to take pre-move out photos. And all of this is done because I've seen situations where there are so many disputes in regarding security deposit where the tenant is arguing that the property did not look like this and so did not look like basically arguing about the condition of the property. So I believe this would resolve a lot of disputes, especially in small claims court, because if there are pictures taken, the landlord can prove that the unit looked like this, and after I got it back from the tenant, there are a lot of damages on the wall, it's unclean, and you didn't clean it effectively, and that's why I charge you cleaning services. So there's that about the security deposit. The next thing I'd like to talk about is the security deposit interest.
Mhm.
So Berkeley is one of those localities that allows interest to accrue on security deposits. And the landlord has to pay the security deposit interest every year. This is usually paid every December. And the landlord has until January 31st of the next year to pay the security deposit. The payment can be in the form of cash to the tenant, or it could be a rent rebate or credit. However, the landlord has to provide notice to the tenant, notifying the tenant that the security deposit interest have been paid, just to avoid disputes. If on move out, the landlord has to pay any security deposit interest that had accrued from the beginning of the year up to the time that the tenant vacated. And this could be on a prorated basis. There are penalties for not abiding with this law, in that if the interest is not paid by January 31st, the tenant may recover up to 10% interest on the security deposit. Another change that we made to the lease involves utilities. And that is if the utilities are not separately metered, the landlord has to disclose that utilities are serving other areas. There are situations where there's just one meter and it's for everybody, every unit. So in that case, what the landlord can do is to set a base rent. And this base rent is fixed, meaning you cannot change it. However, if the landlord wants to increase the rent due to utility costs, the landlord cannot simply increase the rent. The landlord has to petition the rent board and explain to them that utility costs have gone up, and so he or she wants to increase the base rent due to get a fair return, basically. If the utilities are separately metered, then the landlord must disclose this to the tenant and then place the utilities in the tenant's name. The next thing that I saw, which I actually didn't know until Jeff notified me, was the military base disclosures. So on the Civil Code section 1940.7, if the landlord knows that the property is within 1 mile of a former military base and the base involved ammunition or explosive materials, the landlord must give written notice. And this disclosure must be provided before the tenant signs the rental agreement. Apart from this disclosure, there are other required disclosures which must be included in the lease. Some of them have been there for a long time, so I'm pretty sure most landlords know this. For example, the lead-based paint disclosure. This is essentially a form. I can provide you a link to this disclosure. Oh, I'm sure Jeff has the form, right?
Yeah.
Yeah,
That
you can
that
just
one
type
can
it
be
in
done,
Google.
and I think that one can be done by email before the lease is signed. I think it actually needs to be done before the lease is signed. Isn't that right?
Right,
Hmm.
right. So yeah, you can type it up in Google and it'll pop up as a PDF document. And this is basically to notify the tenant of lead-based paint hazards. There's also another one. So there are two disclosures. There's the land-based paint disclosure. This one is if the landlord is required if the landlord knows or has reason to know that lead-based paint hazards are contained in the property. So Jeff, I saw in the lease that you and I didn't notice it earlier. You said that it's only required if testing is performed, and that's not necessarily true. It's only if the landlord knows or has reason to know that the property contains lead. And that is because it's possible that testing was not done by the landlord, but was probably done by the previous owner, or I don't know how the landlord would know, but if for any reason he knows that the property contains lead, he has to provide that disclosure to the tenant. And the other one is what I talked about, which is basically a booklet. The booklet is required for constructions for properties that were constructed before 1978. And I believe this is because after 1978, um, rules were made so that properties no longer contain lead. Properties constructed after 1978 no longer contain lead. Um, Another disclosure is the rent reporting addendum. This is only required for properties that contain more than 16 units. I'll talk more about this later, but generally, the landlord, if your property contain more than 16 units, you have to offer to the tenant the option to report your positive rent to the credit bureaus. Another disclosure which has been there for a long time is mold. It's an informational booklet. You can get it on Google, and I'm pretty sure AOA has it as well. There's also the flood hazard disclosure. This is required if you know that the property is located in a designated flood zone. There's also the regular bed bug disclosure. It's an informational notice, and it's one of the notices that you can get on Google or AOA. One of the new disclosures, this one is not required. So Jeff, I see on the lease you have it bold. You said that the bolded are required by law. So the e-bike and scooter addendum is not required, but I would say that it's recommended. That's probably why you put it in bold. And that's because if it's stated in the lease and then you have restrictions, they are enforceable. However, if it's not stated in the lease, you cannot restrict the tenant. The tenant has, and I'll talk more about this later. Um, but yeah, it addresses storage and safety requirements involving e-bikes and micro mobility devices. Then there's also the pest control addendum. This is relatively new and is required for ongoing or contracted pest control services. If your unit you provide routinely contracted pest control services, then there are some disclosures that you have to provide to the tenant at the beginning of the tenancy, or at least before the initial pest control treatment. All right, so we're gonna go more into that about the e-bike and micro mobility devices. So according to the law, tenants may store one e-bike or e-scooter per occupant unless limited by the lease. So as I said before, it's not required, but it's recommended. So if you do not want a tenant or occupant storing more than one device, it has to be included in the lease. And if it's not included, it means they can store multiple devices. The law also prescribes some battery standards. So a little bit technical, but for the e-bikes, it's UL2849 or EN15194. And for the e-scooters is UL2272 or EN17128. If the battery does not meet those standards, the landlord can require liability insurance. Also, the landlord can prohibit indoor charging, but this is only if the landlord provides exterior storage and charging. And as I mentioned earlier, restrictions are only enforceable if they're stated in the lease. I'm now gonna go into depth about the pest control addendum. And these can be divided into two. It involves licensed pet control and unlicensed pet control. And I see these disclosures in the lease. So if you get your lease from AOA, you're totally covered. But for the licensed pest control, this is governed by Business and Professional Code Section 8538. And this basically states that if the landlord has a contract for periodic pest control, the landlord has to provide the resident a copy of the notice originally given to the owner by the pest control company. Now, this does not mean that after you give notice, you still have to follow the 24-hour notice to enter provisions provided by state law, in that it before any inspection, you have to give the tenant notice that within 24 hours or whenever the inspection is scheduled for, there's gonna be pest treatment or inspections. For unlicensed pest control, this is governed by Civil Code Section 1940.8.5, and it applies when the landlord either applies the pest control, um, basically does the pest treatment himself, or is done by somebody who's not a licensed operator or contractor. There's more requirements for this, in that written notice has to be given to the resident of the unit that's going to be treated, as well as adjacent units, especially if there's going to be foggers and aerosols impacting those adjacent units. And the notice must disclose the pests that are being treated or controlled, the name and brand of the pesticide, approximate date, time, and frequency you are going to do this pest control treatment, and also a state required warning. Is the language that's included in the lease, but it generally begins with caution. Pesticides are toxic criminal chemicals. And then it also has to include this language, basically having the poison control number. But all of that is in the lease. It's pretty long, but once you read the lease, um, or you get your lease from AOA, you'll be covered. The next thing I will talk about is the mandatory stove and refrigerator requirements. This is one of the new laws that went into effect January 1st, 2026, and it amends Civil Code Section 1941.1, which basically has a list of habitability requirements. So for new leases signed, amended, or extended on or after January 1st, 2026, um, the rental unit has to include a working stove and a working refrigerator. It must be in good repair and it has to be safe to use. So this applies, as stated earlier, it applies to tenancies that are amended or extended past January 1st, 2026. Amended here means that any change that you make to the lease. So if you're removing terms, adding terms, even changing the rent, you have to make sure that the unit has a working stove or working refrigerator. However, there are certain exceptions, in that the tenant can elect to have your own stove or refrigerator, and in that case, you are not required to maintain it. However, if the tenant tells you or sends you gives you a written notice that he or she wants you to provide a working stove or refrigerator, you must do so within 30 days and then maintain it. Also, if the particular stove or refrigerator has been recalled, then upon notice, within 30 days, you have to replace it. The lease also has to include certain language. And it basically says that a tenant, anything substantially in this form, it's better to just copy and paste the law so you don't have any issues. But it basically states that a tenant and landlord may mutually agree when the lease is signed if the tenant chooses to provide and maintain their own refrigerator, if all the following apply. And then there's also another language which says under state law, the landlord is required to provide a refrigerator in good working order in your unit. By checking this box, you acknowledge that you have asked to bring your own refrigerator and that you are responsible for keeping that refrigerator in working order. So you must include this language in your lease to comply with the law. There are some units which are exempt from this provision, and they are permanent supportive housing, single occupancy units with shared kitchens, residential hotels, and then units with communal or shared kitchens, for example, assisted living facilities. Note that these rules do not limit a tenant's existing right to repair, induct, or vacate in accordance with Civil Code Section 1942. Next, I will talk about rent reporting. And this applies to properties that contain more than 16 units. So for these properties, the offer can be made at lease signing or at least once annually thereafter. And at least once annually thereafter. And what basically this entails is that the tenant may choose to have positive rental payment information reported to a credible credit bureau. The election may be made by a rent reporting addendum. If the tenant opts in, the landlord may charge a fee, but the fee should not exceed the actual cost of the landlord or $10 per month, whichever is less. And the purpose is to give the tenant an avenue to build credit through on-time rent payments. There are some properties which are exempt from this law, and they include properties that have fewer than 16 units, or a natural owner um, who is not a corporation or LLC, or does not have any corporate member involved, and then the owner does not own more than one rental property. The last thing that I will talk about is the Berkeley Notice of Tenants' Rights. This is basically a form that was created by the Berkeley Rent Board. It's a form that you can look online or on their Rent Board website. And it's given to the tenants along with your lease. And it has a bunch of rules on there, but generally it talks about the rent ceiling. So at the beginning of the tenancy, you can set a base rent. This is usually based on the market value of the unit. And then after that, you can only increase the rent based on the annual general adjustments prescribed by the Berkeley Rent Board. And you can find this on your website. So this means that depending on what the annual general adjustment is for the particular year, for example, if it's 0.3%, you can increase the rent only by that amount. Anything above that is considered illegal. It also provides that you have to register the units for covered and partially covered units. If your unit is fully exempt, you do not have to register. It also talks about petitions, sorry. So the tenant is allowed to petition the rent board for either rent reductions or refund for service decreases or violations. For example, you increase the rent above the AGA, or you increase the rent for utilities, but you didn't go through the rent board. Any issue that the tenant, any violation basically, the tenant has the right to petition the rent board so that the issue can be addressed. It also talks about security deposit interest, and it basically states that the tenants are entitled to interest on their security deposit annually and prorated at move out. Then it also talks about the just cause eviction requirements. Eviction can only be for the enumerated causes. And then for each cause, you have to serve a legally compliant notice. Some note for non-payment of rent notice, you can serve a straight non-payment of rent notices, but some require warning notices. For example, breaches of lease, you have to give the tenant an opportunity to cure before you serve a notice to quit. And then for notices that are for what do you call them? No fault evictions. There are several more requirements. Relocation costs, um, if there are older tenants or tenants with disability, it's a lot. All of this can be found on the rent board website. And then it also states that, lastly, it states that the tenants have a right to organize, but this applies to properties that have more than 10 units. And that is pretty much it, unless everyone has questions or Jeff has questions.
Great. Yeah, thank you for covering that real quick. Yeah, that e-bike addendum. Yeah, you're right. And yet, like, you can't enforce the law without having it in there. So there's some attorneys will say, you know what, it's actually required, even though it doesn't say it's required. So it's kind of like a parsing of words. But man, I'll tell you, if you take a look at that, take a look at that addendum that we've put together there, because there's also there's a lot of information in there that really helps the renter understand lithium batteries and just how combustible they are. So this is going to really save you, and I think yeah, it's going to prevent fires if they just read the
Right.
not what's in our notice, but there's some informational sheets there that are required to be part of it, and they're just it's really good, and I think everyone needs to just remember don't leave a battery in a hot place, right? It's
Yeah.
just common sense, but people really don't think about it. So yeah, so that e-bike addendum, you definitely want to be adding it. And then, yeah, it was the thing that I was trying to, that I couldn't recall before. It's certificate of mailing. That was the specific thing that for sure works in court. Perhaps it would work if you do the self-cert, like the kiosk where you buy the stamp and maybe you could show that in court. But I haven't, who knows whether that is the case or not. But it is Form 3817 because that certificate of mailing is not certified mail. So you could walk up in the post office and say certificate of mailing, and they could offer you the certified mail because that's more expensive. And so just really understand what you're asking for, and Form 3817 on that one, because that one's going to trip you up on just on anything that requires service and, where you're mailing it. Yeah. So I think she was going, Sybil, thank you so much. She was going through, stuff that we have in the form. And I think it would be good, like if you have questions, definitely put them in the chat. But it would be good just to have a visual of what we're talking about. So let me see if I can share it real quick. Okay. So this thing, resident acknowledge receipt of the following, which shall be deemed part of the agreement. Some of these are baked in, but it said bolded items are required by law. So like that's what she was talking about. You can see that these down the right side are required, and then these across the bottom, it's kind of like conditionally. So it's not going to be required for everybody, but here it is. Like if you have 16 units or more, or if you're pre-1978, which is going to be a lot of people, if you have you have a contract with the pest control company. So that's those right there. And anyway, I think everybody's aware of how to access the forms. When you're in the forms here, one thing that you could do is just look at city specific, and then there's Berkeley there. And so like the rental agreement is here. We have a background check disclosure that's specific to Berkeley. Yeah, so application, a disclosure form, the rental agreement, the 3-day notice, the fire addendum. Sybil, maybe you could tell me about that one. But yeah, I'm not familiar with that. But anyway, you can find them here. But it's also like the move-in forms packet is also a great way to just see all the different addendums that could potentially go with it, because there's a lot. There's a lot of different forms that addendum that could go in there. And do you need to have them? It may not be that you need to have it, but lots of times it's important to have it. And even if it's not required by law, some stuff it just makes sense to put it in there. Okay, it looks like we have somebody in the chat. Let's see. For existing tenants, should we supply the e-bike addendum by ensuing a change in terms of tenancy? That is a great question. And Sybil, could you help us
Yes.
out there?
Yes. I'll say yes.
Okay, so yeah, so that's a change of terms. And when they're doing the change of terms, we talked about that one with the stove and the new stove and refrigerator requirements. So when they do that change of terms with the e-bike, then they're probably going to need to include the notice for the stove and the for the appliances, required appliances, right?
Right, but what I will say is Berkeley has this law about unilateral changes in terms of tenancy. So,
Okay.
right. So if you're going to change the terms of tenancy, you have to get your consent. It's possible that the tenant will not consent or sign the change of terms. And if they don't sign, then that means that those terms do not apply to them. So that's
Mhm.
something to keep to have in mind.
Right. And so for most, I know that we've always, generally speaking, I think we've advised people to not provide the refrigerator because when the renter brings that in, they have a little more skin in the game and it's one less thing that you have to take care of. So maybe you guys on the call, maybe you've taken that advice and you're not providing the refrigerator. Um, it could, but I know a lot of people they're not. So if they're not providing anything, there's really not much to, they can consent or not consent, but hey, this is just a state law, letting you know what the state law is, and hey, we're going to take care of these things. Um, but yeah, so it's tough with stuff like that, and you give them a notice for the e-bike may not be applicable, but I sure hope at least they are more responsible with batteries. But
Right.
yeah, so how do you deal with that? What would your advice be when their renters are kind of antagonistic? Yeah, it's not going to be everybody, it's going to be more the minority. Um, very few would be that way, but for the one that's not going to sign it, is there anything else that you could do to
No, there's nothing you can do if they don't
uh,
consent. If it wasn't included at the start of the tenancy and they don't, you try to include it by serving them a change of terms of tenancy and they do not sign it, then it means you cannot evict them for breach of those terms. That's
mhm,
what it essentially means.
right. Okay, let me see. What else do we have? Also, if a tenant pays more than 5% late fee, do we have to return the amount back to them or apply the overage to their future rent?
I would say you can do either or. You can return it or you can apply it, you can credit it to future rent. However, whatever you do, you must give the tenant notice.
Okay. And in 5%, like that's actually it's really is what I've heard from other attorneys, it's actually really up to 6%. Have you,
Okay.
but
I
I
try to
feel
be
like
more
I feel like
cautious than necessary. So what I've
yeah,
seen is generally 5%.
5%.
Well, at least
I
that's what I
know.
advise my clients.
So it's tough because Bay Area, it seems like it's 5%, and then other parts of California, there's case law for 6%. So it's kind of like that's why we wrote 5%, just because it's like in the Bay Area, it seems
Right.
like 5%.
It has to
Um,
be reasonable.
right,
And
but if
I guess as long as you can justify it by actual cost or then you're covered. But if you cannot justify why you're charging more than 5%, then that would be an issue.
mhm. All right, and then I do see a question here about the Alameda in-person seminar, and let's see, is this it? No, that's the San Jose one. Let me pull it up real quick. Yeah, so that's going to be, no, that's not it. Sorry, we got a bunch of events. Let me look here. San Jose, Alameda, there it is. Okay, so Prit's going to be speaking at that one, 10 a.m. and 11:30. It's Alameda Elks Lodge. on Santa Clara Avenue. And the way that you can register for that, if you're a member, it's free for you. If your membership's expired, please get that renewed and it'll be free for you. 39 if you're not a member, but that will be at the Elks Lodge. So it's in Alameda, not in Oakland. I know we've met in Oakland a lot, but this one we're trying to make it in a place where people will feel, that everybody can kind of get to easily. Not everybody, but people up in that area can get to easily. And anyway, so we'll have changes to the rental agreements. And is it really anyway, I'm reading the stuff in the
You
chat.
skipping some other questions. There's this question, does it pertain to El Cerrito enrichment properties?
Yeah,
Yes, some of them pertain to El Cerrito enrichment properties. For example, the stove and refrigerator requirements is statewide.
right.
Rent reporting requirements statewide. However, the Berkeley notice of tenants' rights, that's limited to Berkeley.
Just about most everything, most of the changes here relate to state laws that changed. So there's really, like, Berkeley has a very specific rental agreement and so that's what we are providing because there's a specific language there. But really, like, the late fee wording had to be updated because of new law, that the required appliances that had to be updated, and the security deposit return, based on what the new law says, if you don't have that provision in your lease that says you can email them security deposit accounting, then you can't. So we want to make things as easy as possible for you guys and give you as much legal right as possible. So it's baked into the rental agreement so that you can email about the security deposit. All right, so let's go back to these questions. Also, for owners owning 2 or less properties in Berkeley but own more units outside of Berkeley, is the owner considered owning more than 2 properties for laws of Berkeley? What would you say, Sybil?
Yes, you're owning more than 2 properties. It doesn't say that the properties have to be situated in Berkeley.
We'll push it one step further. What is it? Are we talking about in the state of California?
Yes, I'll say state of California.
Man, these guys, right? Can't believe it. Okay, is it really 4% interest on deposit? Can you believe 4% interest?
Yes, so I posted a link. I have not if you click on the link, it has the interest rates from previous years, and I don't see 4% there.
Right. It's on as a
2025, 0.9, 2024, 1.2. So I'm not really sure where you got the 4% from.
where they got that from, right?
Yeah,
It's
but I've
crazy.
included the link in the chat.
Yeah, so thank you. Thank you for that. Okay. And then you can raise your hand there. If you raise your hand, we can have you do video and audio. That's why we have this. You can keep putting things in the chat, or if you raise your hand, we can have you turn your audio on and have you ask your question and have it be a little more interactive. Here's another question on YouTube. Does the new refrigerator law apply for school dorms as well? And we did list like 4 different exemptions, and I would say that would fall under the exemptions there because it's impractical to provide a stove inside a school dorm, right?
Yeah, because most of the school dorms have a shared kitchen.
Yeah,
So no.
right. And so in that if you look at the new rental agreement, it lists like 4 different instances where it's exempt, and that would be one of them. If they are okay, the next one, Veronica on Facebook, if they are sharing 1 meter for a triplex property for the water bill, can we charge a flat fee per unit?
Yes. But it should be included in the base rent at the beginning of the tenancy.
So it's not we're not talking about a change of terms, but if you start off that way, you can do it.
Correct.
Right. In San Jose, you can't do that in San Jose, right? Rubs is illegal?
We don't usually get San Jose cases. It's mostly in the
Okay.
Bay Area, so
All
I'm
right.
not particularly sure on that.
Okay. Well, great. So those are the big changes for that lease. And again, um, we're coming up with a 3-day, 30-day for Section 8, the Section 8 tenancies, like a 3-day notice to pay rent or quit. We're coming up with that. Should be available soon, but I think it's important. Sybil, have you seen any cases thrown out where they didn't have the date of expiration of the notice on the pay or quit? Have you seen any of those cases or heard about any?
Um, Not personally, but I heard about that case law. I forgot the name. That's when we were first notified about that provision. But
Yeah.
no, I have not seen that happen in court.
Okay. And hopefully you won't. Hopefully if everyone uses the newest one, then we'll be all right. Everybody will be okay, hopefully. Um, great. Well, again, yeah, next week at the Elks Lodge in Alameda, and probably you won't want to go to the one that's in San Jose. So, if you want to come in person, Pritt will be there. Another attorney that's with Beckman Feller and Chang. So he'll be there for that one, and we'll go over rental agreement and eviction notice changes then one more time. And again, don't forget there's that new municipal code for Berkeley when you're giving the rental application. There's new code language that needs to be in there. So don't forget about that one. And let's see. All right.
Oh, that was me. I included the PowerPoint presentation for
Oh,
people
cool. Okay. For PowerPoint for,
for the present what we just did. So everything I talked about is included in there.
oh, really? I didn't see it didn't present, I guess, or we couldn't see it.
Yeah, I couldn't share. Oh,
Oh,
okay, I could share now. Oh, when I started that, I couldn't share.
oh, darn. All right. Well, hey, everybody, thankful for you. And I hope we really believe this is going to be a great year. And yeah, I just wish you the very best and health and peace and success with your rental properties. So take care. Bye-bye.
Bye.
Okay, Sybil, thank you so much.